So put your trust in living trusts. So the agenda today will be trust basics. We're going to talk about a last will and testament because I get questions like, well, do I need a trust if I have a will? Uh, do I need a will if I have a trust? The bottom line answer is you really should have both for most individuals, and we'll explain why. We're going to go over other important legal documents, and you may not realize that all of the documents that an attorney will draft, they all mesh together. They all interface with each other. And you have to understand that the attorney looks at the whole picture. So the will, if you have a trust, the will might be a very different will than you would have if you didn't have a trust. The power of attorney certainly will be different. Other documents will interface together with that trust. Then we're going to be talking about types of trust, revocable, irrevocable, simple versus complex, living trust versus testamentary trust, which are trusts and wills, grantor trusts. A lot of people heard of it. They don't understand it, but today you're going to understand it. We're going to talk about the Medicaid Asset Protection Trust, and you'll see why that's truly the gold standard way to protect assets. We'll talk about the Pooled Income Trust and how that helps Medicaid home care recipients on a monthly basis. We're also going to talk about minors trusts, special needs trusts, spendthrift trusts, and life insurance trusts. And a trust is a great way not only to protect assets for Medicaid purposes, but also to protect assets vis-a-vis estate taxes. So we'll go over the estate and gift taxes, how that works on a federal basis, and how that works in New York State. So let's dive right in. Let's talk about trust basics. So what is a trust? A trust is an agreement that creates an entity. So we have this agreement, it creates an entity, and that entity holds assets. Like a corporation might hold an asset, or someone in my office uses, as a way to teach this, think of it as an envelope that holds assets. And that trust agreement dictates how those assets are held, how they're managed, who manages them, and how they are to be distributed. And that agreement, that trust agreement, provides all of that. And every trust is different depending on what our goal is. I had mentioned a Medicaid trust. Well, that's very different than a revocable living trust, which is very different than a special needs trust, etc. So they're all different. So a lot of times people call my office, and it sounds very silly, but I've heard it this week. Mr. Fatula, we want a trust. And I said, okay, why do you want it? Well, because I know a friend of mine got a trust and it works so well. And I said, but why do you need it? Everyone's situation is different. They didn't know. They just wanted it. Well, that's silly. But the first step is to know what it is. So a trust is simply an entity that holds assets, and the assets are managed and distributed, and all of the rules are set forth in the trust agreement. Okay. What is a testamentary trust? A testamentary trust is a trust that's put in a will. So with a testamentary trust, what we actually do is write that will and write that trust, and that's put into and is a part of the last will and testament. And of course, the testamentary trust is not good until after death. So how is that different than a living trust? Well, a living trust is a trust that you sign right here, right now, and it's good right now. It's signed by the creator of that trust and the trustee, and we'll get into that. How do you fund the trust? It used to be years ago, when I first started to practice, used to be that you could just sign a piece of paper saying, I hereby assign everything into my living trust. You can't do that anymore. In order to get an asset into that trust, you actually have to assign the asset into the trust. So for example, if you have a bank account, the title on that bank account has to change for that bank account to be part of the trust. So it has to go into not the trust per se, but it goes to the trustee of that trust because the trustee controls the trust. Same thing with a brokerage account. Same thing with a home. Same thing with a commercial property, etc. The next bullet point asks, well, how do I get personal property into the trust? I have, and it's interesting, this week, I had a wealthier client buy $2 million worth of artwork. And she said, well, I got to put that into my trust. How do we do that? How do you put your diamond engagement ring into the trust? Well, it's simple. We just have to do an assignment of that artwork or that diamond engagement ring into the trust. And the assignment is very simple. For example, I hereby assign over to, for example, John Jones, the trustee of the Jane Jones Living Trust, dated so-and-so date. It's as simple as that. But as long as there's a specific assignment of that personal property, that property will be a part of the living trust. And when does that trust end? So you know what a trust is. When is it terminated? Well, actually, the trust is terminated according to the terms that we set forth in that trust agreement. So for example, the trust could end upon the death of the creator of the trust, or it might end within 10 years, or it might end upon the death of a spouse or a child. You could say virtually anything that you want as far as when the end date of that trust is. However, in New York State, unlike some other states, you can't have it go on for generations and generations. But it can terminate upon all the lives in being. And we went into this in law school, very interesting concept called the rule against perpetuities. What does that mean? In New York, at least, you can't have this go on forever, but it can last for the duration of all the lives that are here right now, plus another 21 years. So we could have it go out to children, grandchildren, etc., but you can't have it go out for generations and generations, at least in New York. You can in some other states. Okay, so we're still on the trust basics. Who are the parties to this trust? Well, you have the individual that creates the trust. That's the creator. The estate planning attorney typically will do all the drafting, of that trust agreement to accomplish the goal of that trust. So the creator of that trust will go to the estate planning attorney and discuss the goals that the individual has, that creator has. It might be reducing estate taxes. It might be protecting the home for Medicaid purposes. The attorney drafts that trust agreement, creating the trust. But the parties to the trust, we have the creator, also known as the grantor, Grantor, also known as the settlor, Settlor. So we have the creator, the grantor, and the settlor, all the same person, individual that's creating the trust. So if I want a trust, and I do have a trust, I'm the creator. But I need somebody to manage the assets of the trust in accordance with the terms of the trust agreement. That individual is called the trustee. Now, that trustee can be me if I'm the grantor. So the grantor / creator can also be the trustee depending on the type of trust it is. Or you might name a child or a spouse or a third party. Anyone who's 18 years of age or older can be the trustee of the trust. And then we have beneficiaries of the trust. So we have the creator, the trustee. Trustee could also be the creator as well, and beneficiaries. And there's several different types of beneficiaries. For example, let's say the creator, the grantor says, I want to benefit from this trust. I want the income for life. And that is the income beneficiary. So that's fine. So the income beneficiary of that particular trust might be the creator of the trust. And the creator might say, well, I want the income for life, but upon my death, I want all of the assets to go to my children equally. And that's fine. And the children are called the remainder persons. So we have different, and they're beneficiaries. So we have different categories of beneficiaries as well. So the question is, and I get this all the time, do I have to probate a trust? Well, let's get to the definition of probate. Probate is when you have a will, not a trust. I have it under trust basics because everybody confuses this. Probate is when you have a will that's going to control assets. Let's say you don't have a trust and you don't have assets with beneficiary designations, and you have a will. Well, that will has to be probated. And probate, if you see the definition right here, is a court-supervised proceeding. And the court looks at the will and makes sure that that will is authentic. It's a true will. There is no monkey business. There was no fraud. There was no duress, etc. And it's so interesting. What the surrogate does, and people are not aware of this, they get a copy of the will, and the surrogate actually takes out a magnifying glass and looks at that will to see if there are any staple marks, if the staples were removed from the will. Why? It's part of their job to make sure that the will is kosher, authentic, there was no fraud, there was no duress. They want to make sure that nobody took out the staples and stuck in a page that said, well, all assets go to me, not your children, my children, something like that. So the court really takes this very seriously, and it's really for everyone's protection. But that's what probate is. Probate has nothing to do with a living trust. It's when you take a will after somebody dies, and we go through the process where the court says, okay, this is a valid will. There's no duress, there's no fraud, there's no undue influences, and we, the court, the surrogate's court, accept the will for probate. That's when the executor of the will that's nominated in the will takes over, just like the trustee of the trust. The executor of the will manages the assets and eventually distributes the assets to whoever you wanted those assets to go to. Could be a spouse, it could be children, it could be a friend, it could be a charity. And just flip that over to a trust. The trust could have those beneficiaries as well. It could have individuals, it could have a charity, etc. It could even be a pet. I don't know if you guys remember Leona Helmsley. She left $12 million to her dog. Can you do that? Sure. I have clients that have horses, and they have me set up a trust for the horse to make sure that there is enough money there to take care of the animal for the animal's lifetime. And then when the animal passes away, then it goes to the other beneficiaries, maybe to children or to a charity, wherever they want it to go to. But you can't even have Fido be the beneficiary of your trust, or a charity, etc. So now you know what probate is. What is ancillary probate? Ancillary probate is when, let's say you or an individual passes away in New York, but has a condo in Florida. So without a trust, what do we have to do in New York? Probate the will to make sure that the assets go, let's say, to the children. What happens to the condo in Florida? Well, we have to do, not we, but someone in Florida has got to do ancillary probate in Florida. So you have two probates. And I remember when I went to law school, the professor said, day one, he said, when do you use a revocable living trust? And here are some of the, what, client wants to avoid probate, et cetera. And one of the first things he said, if your client has property in 2 states, real estate in 2 states, well, it's a no-brainer. We want to avoid probate in New York, but we also want to avoid probate in that other state. And that's what the trust will do as well. You want to avoid probate, but especially ancillary probate. So you don't have to go for 2 probates. And you can imagine if you have property in 3 states, we have a couple of clients. One client I remember has a property in New York, a little condo in Florida, and something in Carolina. So some people have the life, but you definitely want to avoid probate anywhere, but especially 2 probates or 3. So let's talk about a will for a second. So again, a will is a document that sets forth where your assets go when you pass away. But it doesn't pertain to assets and trusts, and the will does not pertain and does not control any assets that you already have a beneficiary designation on. A lot of people confuse this. So let me give you an example. Let's say I have a bank account, a Capital One, and let's say I have $50,000 in it. And the beneficiary of that bank account would be my 2 children. Okay, so when I die, that bank account will go to my 2 children. All they have to do is show a death certificate. What if I have a living trust, though, that says all of my money goes to a third party, not my children, but I have this one bank account where the beneficiary would be my children, but my will says it goes someplace else? Well, the will does not control. The beneficiary designation controls before the will. The trust, the living trust, will control before the will. The will only controls assets that are not in the trust and that do not have beneficiary designations on them. Okay, so a lot of people get confused by that. So just remember that. Okay, why do people do wills and not trusts? Well, it's silly. Most people should do both. If you just have a will and you're not protecting assets for Medicaid, or if you have an estate tax issue, the will make sure that your assets go to the beneficiaries you want, but you don't get other protections. And we're going to go through that. So wills versus trusts. Well, you already know that if you have a will, and if the will is going to control an asset, i.e. if this asset is not in a trust or there's no beneficiary designation, well, you have to go through the probate process. Now, the probate process is not awful. It's bad in other states. It's not terrible in New York, but it is a process, and it's a good idea to try to avoid it. But what are the advantages of a trust? Well, number one, you avoid probate, and you avoid ancillary probate for properties that you might have in another state. When you probate a will, it's a matter of public record. With a trust, everything is private. With a will, you have to go through the probate process, and the probate process typically takes at least 7 months, but there's ways to get expedited letters testamentary to control the assets quicker, but you can't get assets out extremely quickly. Why is that an issue? Let's say you have a special needs trust for a disabled child, or you have a trust for a daughter, and the disabled child needs something right now, or the daughter needs something right now. Well, you don't have to wait for the probate process. The assets in the trust can be distributed almost right away, and that's a big deal. Now, when you probate a will, a lot of people don't know that part of the probate process is where individuals, family members that would have gotten, if there were no will, have to get a notice that there is a will and that they have a right to come and contest the will. So they actually get a notice here, son, John Jones, you're the son. John Jones will get a notice saying, if basically in English, if you want to contest the will, come down to the surrogates court in Manhattan on so-and-so date, and you could contest this will. So if there's a situation where the family members are not on the same page, or you're not giving equally to children, or a spouse is cut out for various reasons, and somebody wants to contest, or there's a problem child, etc., you definitely want to do a trust which doesn't go through that process. It's a very, very different thing. And if we know, or the attorney knows, that there's an issue, what you can put in the will and what you can put in a trust as well, I don't have it on the slide, but it's called an interorum clause. And right before this seminar, I was actually just working on an interorum clause. An interorum clause, and it's spelled just the way it sounds, interorum clause, basically provides that if anyone contests the will or the trust, then if they lose that contest, then they lose their inheritance, or they lose whatever they were going to get. So let's say there are 3 children, and let's say child A gets 40%, child B gets 50%, and child C gets 10%. If you have a will, all 3 children are going to get a notice saying you could go to the surrogates court and contest this. If child C gets this notice, he can contest, and then there are issues. You have to go through the process. It's quite difficult if the attorney drafted the will. There's a presumption that it was signed the right way, and that goes a big way, it goes a long way in making sure that the surrogate accepts the will. So for all of the other estate planning attorneys that I know of, and in my firm as well, there's never a will that was contested successfully. However, we had several contests. A child might have contested, but it was not successful. what happened in a couple of cases, the other child might have said, okay, you know what? The hell with it. I'll give you a little bit, just go away. But with that inter rorem clause, that stops a contest in its tracks many, many times. So just keep that in the back of your head. But the trust doesn't go through that process. It really does help to avoid the will contest if you think there might be an issue. Now, continuity of management. When you have assets in a living trust, and God forbid, if you should become incapacitated, what happens to the assets? Well, they're still in the living trust. They don't have to go anywhere. And the successor trustee that you named in the trust, let's say you're the trustee of your living trust. If you become incapacitated, the successor trustee, for example, maybe you named a daughter. Well, the daughter just becomes the trustee and handles everything. Everything is under one roof. You don't have to show any other documents. It's very, very simple. You have continuity of management, and that's a very, very simple thing. Now, remember earlier I said that other legal documents, when the attorney knows that you have a trust, a living trust, other documents might be done differently because the plan has to be a holistic plan. So the documents talk to each other. So you know what? Let me just talk about this now. So for example, if you have a trust, we may do a different type of will that says all of your assets will go into that trust upon your death. So any assets not already in that trust will go into that trust. And that's called a pour over will. That's the legal term, but it's like you're taking any assets not in that trust, and that'll go into the trust. And your power of attorney will actually also interface with the trust as well. There are many provisions. When we know that you have a trust, you got to change the power of attorney to provide for extra provisions that will work with that trust. Okay, so here we have, let's step back for a moment. We have two general types of trusts. We have living trusts. Those are trusts that you sign right now while you're living. And we have testamentary trusts. Those are trusts that are in your will. The trust is all written up and it's put in the will, and the trust becomes valid only after the will is probated. Living trusts and testamentary trusts. But now, as far as living trusts, we have two broad categories. One is a revocable living trust, and one is an irrevocable living trust. So what is a revocable living trust? As you can imagine, a revocable living trust, and I think the title of it gave it away, is a trust that you, as the creator, could revoke. You could amend it. You could do whatever you want with those assets, because in essence, they are assets. It's just that you do avoid probate with the assets in the trust. You do avoid Medicaid recovery. You do have other benefits with that living trust, but you could revoke it, you could amend it, you could control the assets any way you want. Why would someone ever do an irrevocable trust if they could control the trust? Well, if there's a goal, let's say to protect assets from Medicaid, we may have to do an irrevocable trust. But no fret, do not fear. The way most attorneys draft those irrevocable trusts, they make it so simple, and I know it sounds counterintuitive, but so simple to revoke even an irrevocable trust. The trust just has to be drafted the right way. So the Medicaid trusts are typically irrevocable trusts. The trusts to do or to reduce estate taxes are typically irrevocable trusts. But again, those trusts can be revoked under most circumstances if the trust is drafted the right way. Okay, so the trust avoids probate, ancillary probate, and gives you a lot of control. It's a great thing, depending on your circumstances and what your goals are. An irrevocable trust, well, we went through it. The trust on its face is irrevocable. And if the trust doesn't say anything, whether it's revocable or irrevocable, that trust is irrevocable. It's interesting, when I went to law school many years ago, and I learned that in my trust and estates class, I just thought that was so counterintuitive. I thought that if you're putting your own assets into a trust and you don't say anything, the trust should be revocable, but it's not. It is irrevocable. But any good attorney will make sure that the trust sets forth whether it's revocable or irrevocable, even if the presumption is irrevocable if you say nothing. So we might have an irrevocable trust for Medicaid, or to reduce estate taxes, or to get a life insurance policy out of your taxable estate, or to make sure that creditors can't get at your assets. There's so many reasons to do the irrevocable trust, but it doesn't mean, again, that you can't revoke that trust. I know it sounds counterintuitive, but you can, in most cases, revoke the irrevocable trust. Now, I'm not going to spend a lot of time on this, and you just might have heard the terms simple versus complex trust. And that doesn't mean that a trust is simple to create or complex to create. But a simple trust, let's just look at the slide here, because you're going to see that term, and it has nothing to do with the complexity of the trust or whether that trust is simple. But a simple trust is where all of the income of that trust is distributed to the beneficiaries. Whereas with a complex trust, the income is not all distributed to the beneficiaries. With a simple trust, you can't distribute principal. But with a complex trust, you can distribute principal. With a simple trust, you can't make distributions to charities. With a complex trust, you can. And then we go into some of the tax issues. So you're not going to need that, but many times people talk about a simple trust or complex, and many of my clients say, oh no, a complex trust has nothing to do with the complexity of the trust. So I just wanted everyone to know that. I think we went through much of this already. The inter vivos or lifetime trust, good right now. The testamentary trust, a trust within the will, and it only comes into existence after that will is probated. Okay, and I think we went through the rest of this slide, except for one issue. You need to know that in order for a trust to be revoked, you need the consent of the creator, the trustee, and the beneficiaries. A good attorney will actually make it so on a living trust, you only need the consent of the creator and the trustee. There's a technique, there's a way to do that. And that makes it much easier. And you could actually nominate yourself or a third party that you have absolute trust in, and you could therefore always revoke the irrevocable trust. But what about the trust in a will, a testamentary trust? Don't forget, you need the consent of the creator, the trustee, and the beneficiaries. When somebody dies, if the creator dies, because don't forget that trust is in the will, so the creator is gone, that means that every testamentary trust is, by its nature, an irrevocable trust. Just want to make sure that everyone understands that. Now, very importantly, you probably heard about grantor status of a trust, and it just, zooms over your head and your eyes glaze over. I'm going to simplify this, and it's a very important tax technique. Now, a grantor trust is a trust that it's a trust where the IRS views who's going to pay the taxes on the income. With a grantor trust, the grantor or the creator or the settlor, person who creates that trust, will pay the income taxes on the income. Very interesting. What if the income, let's say you set up a Medicaid trust, but you have a great pension and you don't need any of the income. And you don't want Medicaid to get their grubby hands on that income. So you could actually have this grantor trust. You're protecting all your assets for Medicaid, and the income could go to the children. But if it's a grantor trust, guess who has to pay the taxes on it? The grantor. So grantor trust means, and there's a section of the IRS code, sections 671 to 678, and that's on the slide at the last bullet point. And it's actually fun to read, but if you fit with any of those categories, then it's a grantor trust. And even if the income goes to the children or to a third party or into another trust, the grantor still pays the income taxes on it. Why is this good if we're trying to get assets down for estate planning? Well, we're not bulking up the estate because the income is going to a third party, but the creator of the trust, the individual who has big bucks here because they're doing estate planning, they're also reducing their estate with the income. Or for Medicaid purposes, it's a way to reduce the income so Medicaid gets less income on a monthly basis. So grantor trust is simply a type of trust where the creator of the trust, the grantor, is charged with paying the income taxes on that trust, no matter where that income goes. Okay, and that's simply it. So now you know what it is, totally simplified, and this is a strategy that the attorney will use quite often. And you have these slides available to you so you can go over some of this in greater depth. And you could have a grantor trust, a revocable living trust is inherently a grantor trust. So you're going to pay the income taxes on that income. An irrevocable trust can be a grantor trust as well, if there are certain provisions in that trust which are on this slide. For example, you getting the income, or for example, you're having a provision where you control who ultimately gets the assets of this trust, or you have the ability to exchange the assets in this trust for equal value, et cetera. You have the right to change the trustee. And that's another provision that good attorneys may want you to consider in your trust, depending on the circumstances. So let's move on to the Medicaid Asset Protection Trust. And this trust is truly the gold standard way to protect assets for Medicaid. You know, Medicaid has a 5-year look back for Medicaid nursing home care. So we want to try to do this planning at least 5 years before you need Medicaid. And so Medicaid nursing home care has a 5-year look back. We actually have on the books a 2.5-year look back for Medicaid home care, but that will not come into effect until not April 1, not even of 2023, April 1 of 2024, and possibly after that. And I'm on a committee that's trying to actually get that law thrown out. So let's see what happens with that. I'm keeping my fingers crossed. But for now, the Medicaid Asset Protection Trust is the gold standard. And we're going to be talking about why and how you get to have your assets out of your name, still get the income, or if it's a home in that trust, still get the right to live in your home, get all of the tax advantages, which are huge, and you get to continue to live in your home, get your income, and in almost all instances, it can avoid Medicaid recovery. That's very, very important. So what are the advantages? Do you have a home and you put your home in the living trust? Well, you could live there as long as you want. If the home is sold during your lifetime, you get the $250,000 exclusion from capital gains. That's section 121A of the code. That's pretty good. Husband and wife will get a $500,000 exclusion from capital gains, even though it's out of your name and it's being held by this trust. And upon death, if the home is still in the trust, there's a basis step up. So let's step back now for a minute and let me give you an example. Let's say Jane wants to do some planning. She's, let's say 65, 70 years old, and she has a home. She has some IRAs, and she has some assets. She says, Ron, I want to do some Medicaid planning, but I still want to enjoy my assets. So I have a home, it's valued at, let's say, $750,000. It could be a home, it could be a condo, it could be a co-op. She said, I want to protect that for Medicaid purposes. What can I do? And I said, well, the best option is to put that into the Medicaid Asset Protection Trust. And she said, well, why can't I just give that home to my kids? And I said, well, how much did that home cost you? And she might say, because I hear this all the time, well, I bought the home 40 years ago or 50 years ago. We paid $50,000 for the home, and we put about $50,000 of home improvements into that home. So your basis for capital gains tax purposes is $100,000. If you just gave that home to your children, they get a carryover basis. Your low basis will go to the children. And whenever that home is sold, let's say the home is worth $1.1 million, they're going to have to pay capital gains taxes, in my example, on $1 million. $350,000 possibly in capital gains taxes. But if that home went into this trust, upon death, you'll get a basis step up, which means that the low basis of $100,000 will move up to whatever the market value is at death. If it's $1.1 million, the new basis will be $1.1 million. And whenever your children sell that home for $1.1 million, for example, there's zero capital gains taxes. It's a very good way to get the asset out, let you get that capital gains tax exclusion, that $250,000 if the home is sold during lifetime. And of course, your home can be sold during your lifetime, even if it's in a trust. If you want to downsize or upsize or do whatever you want, or you just simply don't want that home, the trust can do it. And the trust can have you downsize, upsize, you decide on what you want. But you get all of the tax advantages, the capital gains tax exclusion, and the basis step up, which is really wonderful. And of course, you get protection from creditors and children's creditors. Don't forget about that. If you transfer assets directly to children and they have a problem, or they're a doctor and they're being sued, your assets that they're holding or that house can be subject to your children's creditors' claims, and that is a huge issue. What about brokerage accounts? Well, we're in the middle of a very rocky stock market. It's gone down, it's gone up a little bit, it's so shaky. But if you have capital gains, just like with the house, you bought Apple stock at the IPO. I don't know anybody who has, but it's a fantasy of mine. But if you did that, you have these huge, huge capital gains. Well, if you want to get that asset out from Medicaid without transferring that very low basis to the children or whoever your beneficiaries are, just put it into the trust. And just like the house, you'll get a basis step up. So that's why we typically put the home and brokerage accounts into the living trust for Medicaid. It's the Medicaid Asset Protection Trust. It is irrevocable, but the way a good attorney would draft that trust is to make sure that you have the ability to revoke it. So we do these trusts almost every day because it's so popular. Why is it so popular? Because it just really works. Many times people ask, well, maybe I need a pooled income trust. Well, you don't need a pooled income trust unless you're on Medicaid home care. A lot of people hear these terms, and let me explain what a pooled trust is. A pooled trust is when a charitable organization creates this pooled trust, and when if you are a Medicaid recipient, you want to preserve your income because the Medicaid income level for 2022 is only $954 a month. But you have income of $4,000 a month, let's say, and you need that income. Well, we take the surplus income, that extra income, and it goes into this pooled income trust that's created by a charitable organization such as NYSARC on the slide or River Spring. So they would create this trust and you would join that trust. So then you won't be limited to Medicaid's income level, currently $954 a month. Who could live on that? To whatever your income is. Next year, that $954 is going up to over $1,500. But even so, who could live, unless you have a really good rent-controlled apartment, but who could live on $1,500 a month? But if you have income of $2,000, $3,000, $4,000, whatever it is, you want to get to use that income if you're on Medicaid home care. The pooled income trust lets you do that. And so I'm going to skip over some of these slides, but it basically goes into what I was talking about. But look at that, looks like the third bullet point there. The number is going up quite a bit, about 50% to about $1,563 of income a month and still be able to stay on Medicaid without the pooled income trust. But it's simple. So we do this, the elder law attorney just does that all the time. If you want more information about the pooled income trust, it's right there on the slides, but I went over the basics. It's there if you want Medicaid home care and you want to get to use your income. If it's over the Medicaid level, you could live your life. We also do trusts for minors. You may not want assets to go, whether that's in the will, that would be the testamentary trust, or a provision in your living trust that says, and might even be in your Medicaid trust. You might say, I don't want my grandchildren, or if you're a younger individual, my children, to get assets when they're 18 years of age. I want that, they're not going to be in control of hundreds of thousands of dollars or whatever it might be at 18 years of age. They might go out and buy that little red Corvette, as Prince said, or whatever it might be. You don't want that. You want that money there, I assume, for their education, for their maintenance and support. Therefore, in the trust, or in your will, we can provide for a minor's trust and have that money go to that individual later than age 18. So the example on the second bullet point, for example, is a third at the age of 21, half of the balance or another third at age 25, and the remaining balance at age 30, or any permutation. You might say, well, I have a child or a grandchild I want to provide for, but I don't think he's really mature at all. I don't want him to get anything until age 30 or 35. You can do whatever you want, but you can have a minor's trust to protect the assets for that minor. Okay, and that's really important. We do these all the time. What if there's a child or any individual with special needs? You want to provide for that individual, but what if they're already on benefits? They might be already on SSI, supplemental security income, and getting a stipend every month, and Medicaid. They're already on Medicaid. So what if you want to provide for them? You want to get your assets out, but you don't want to give them the assets because then they're going to have to go off their benefits. Wouldn't it be better if you could set up within your living trust or your trust within the will, the testamentary trust, for a disabled child or any disabled individual, a special needs trust that will be a war chest for that individual, that disabled individual, whatever they need, while still preserving all of their benefits like Medicaid, that healthcare that they can get, and the stipend that they might be getting, for example, SSI. It's a great way to do things, and it's in the law. You know, our law in New York State provides for special needs trusts, and it's wonderful. You might hear the term a D4A trust because that's the federal law. So there are many different types of special needs trusts. A third-party trust is when a third party, let's say you, will provide for a child or a third party. It's your money, but you're providing for someone with special needs. The self-settled special needs trust is when there might be an inheritance by that child with special needs, and they create this trust so they could stay on Medicaid. For the self-settled trust for Medicaid, they have to be under 65 and just know that Medicaid might have to get paid back for any of the monies that they spent. But at least they could use their money during their lifetime. Now, if you want to provide for a child or a third party who's a spendthrift, they can't hold on to money, and you want to provide for them, you love them, but you want this money to last, we could create a spendthrift trust where the assets are doled out over time, or the trust could be discretionary, or there could be a combination of the two. But the spendthrift trust is a trust that protects assets for a spendthrift individual who can't really hold on to money, or will just not manage the money well, or maybe be influenced by a spouse that will have this money gone. I did talk about Irrevocable Life Insurance Trust. What a great way to get an asset out of your taxable estate if you have a larger estate. We use these trusts all the time for wealthier individuals. For example, recently a client came to me, had about $6 million in assets. I'm sorry, $6 million, not in assets, but in this trust alone of life insurance. So the death benefit was $6 million, but the cash value was zero because it was a term policy. And I said, well, you're butting up to the New York State estate tax level of about 6 million, 6.11 million, just with this life insurance. And so he said, is there any way to get that out of my estate? We transferred the life insurance into this Irrevocable Life Insurance Trust. It's called an ILIT. And the asset is out for tax purposes. Simple as that. You don't reduce any of your estate and gift tax exclusions because there was no cash value. A very simple way to take an estate that would have been very taxable into a non-taxable estate. So that's really important. The next slide goes into what assets comprise your taxable estate. And basically, it's almost anything you can think of. Why? Because the government wants to tax wealthier individuals. It's your business, it's your home, they're your IRAs, it's your life insurance that you own. It's anything you could possibly think of. It's your artwork, etc. Why do we do estate and gift tax planning for wealthier individuals? Because the gift and estate tax rate for federal purposes is 40%. If you're subject to the tax, just federal is 40%, and New York State's rates range from 3% to 16%. But the exclusion is pretty good. Currently, for federal purposes, every individual has a gift and estate tax exclusion or exemption of $12,060,000 going up next year. And I do see a typo on that second bullet point on the left-hand side. Next year in 2023, it's going up to 12.92 million, 12,920,000, not 12,090,000. So that's huge. But the federal numbers are going to be halved at the end of 2025 in a couple of years. New York State's level is $6 million. But just like my client who has a couple of million, 2 million, but $6 million of life insurance, we got that life insurance out. Now we won't have a taxable estate. But New York State's estate tax level is $6 million. I see that my time is just about up, but you have some more information here. For example, New York State has a 3-year rule. New York State, by the way, doesn't have a gift tax. Federal does have a gift and estate tax. New York State just has an estate tax when you die, but they claw back any gifts made within 3 years of death and put them in your taxable estate because they want to tax you as well. So, Lori, I do want to thank you so much.
Okay, Ron, yes, we thank you too. And we've got a lot of questions that
we do. I'm happy to answer them.
Yeah, okay. So,
okay, sure.
Some of them are going to seem a little bit disjointed because they go back to the beginning of the presentation, but
sure. But Lori, should I stop sharing my screen or leave it the way it is?
You can just leave it the way it is.
Okay, sure, you got it.
Okay. If you have a will and a trust, can you avoid probate altogether?
Absolutely. But it means that you're going to have the assets held by the trust or beneficiaries on the assets. And one caveat, please don't just transfer your retirement accounts into a trust. That would be a taxable event. A big no-no, not for retirement assets.
Okay, what happens if the trustee of an irrevocable trust dies after the person who created the trust dies?
There would be, on any trust that a good attorney would draft, there would be a successor trustee, secondary, and even a tertiary trustee.
Okay.
And if not, and if there aren't any, the court will actually appoint a trustee.
I understand that some states, such as Pennsylvania, have easy and inexpensive probate. So if you don't have other reasons to do a living trust, such as privacy, or out-of-state properties, the simplicity of just creating a will is okay. Do you agree?
I agree, but most people do want to avoid probate or protect assets for Medicaid. There are other reasons to do it. But yes, I mean, if that's the way you feel, and you're in a state where probate is very, very simple, why not?
Okay. what is the average price to create an irrevocable trust, not having assets other than a home and a little bit of savings?
Okay, well, I'm just gonna go over average price. I'm not talking about my firm per se, but just generally from what I see, it ranges from about 3,500, and I know some firms that charge about 8,500. It varies, so
Okay.
and I
I
think
have
yeah.
I
Go ahead.
have 2 million of deferred annuities. Can I do Medicaid trust planning? Does it matter whether I'm drawing them down as cash withdrawals?
If the 2 million are retirement accounts, you don't want to touch them. That would create a taxable event. So if it's a TDA, a tax deferred annuity, let's say you're a member of the UFT and you have this big TDA, that's a retirement account. You can't put those in a trust. Not a good idea. But if there's a tax deferred annuity that you went out and purchased, that can go into the trust and you could do Medicaid planning. But there are tax ramifications that need to be looked at quite closely by the attorney.
Okay. New York estate taxes are 6 million for an individual. How do I get the limit for other states? And I thought life insurance was not taxable. That's all from the same
Life
person.
insurance federally. Life insurance owned by an individual within 3 years of death. Even if you gave that life insurance up 2.5 years ago and then died, any life insurance owned within 3 years of death is taxable by the federal government. How would you know what the estate tax limits or exemptions are in other states? Many states don't have an estate tax, such as Florida, Texas, etc. I would use good old Google, to be quite honest.
How difficult is it to change the trustee on a trust?
It depends on how that trust is drafted. If you're if it's a revocable living trust, it's very, very simple. With an irrevocable trust, it could be simple as well. But don't forget that you're the one that gets to choose who that trustee is.
Right, but if the trustee has passed and another trustee becomes non-functional,
then yes, the trustee passes, we would have a secondary trustee, a tertiary trustee. You want to go down the line in case that happens. And if not, then the court will actually order that an individual will become the trustee, someone that petitions the court, which the attorney will handle, and it's not a complicated situation. But we did, easily just make sure you name people that are secondary and tertiary.
if you really want an MAPT but don't have anyone to name as trustee, what options are available?
You could have a trusted member of your team act. For example, you could have a financial advisor, maybe your accountant, maybe a close friend, possibly the attorney. I don't think it's great practice for an attorney to do that, though. But it could be anybody that you feel comfortable with.
Okay.
And when I mean comfortable, that you trust implicitly.
Right. Okay. Well, we're going to take one last question.
Sure.
If someone is on Medicaid and receives a large retroactive benefit from Social Security as a disabled adult child, and the family sets up a special needs trust, did I understand you to say that Medicaid can recoup from the estate? Whoops.
Recoup from the estate. Okay, I know what you're talking about. So let's say there's an individual who's under 65 and there was a negligence lawsuit and he just got, let's make this a juicy example, $1 million from that lawsuit. Or that disabled individual got $1 million of an inheritance. Now what? If that individual is under 65, that individual can create, or the parent or a guardian or the court can create an under 65 Medicaid payback trust and stay on all of his or her benefits. So that disabled individual now can take that $1 million, put it into this self-settled, meaning that it was the disabled individual's own money, creates this self-settled trust and use it. They could stay on Medicaid, they could stay on SSI and have this war chest, but upon death, if there's any money that's still left in that trust, Medicaid can pay themselves back, not SSI, only Medicaid can pay themselves back exactly up to what was paid by Medicaid. The rest of the assets could go to other family members or anyone else.
Okay, well, Ron, we thank you so much for your time and sharing your knowledge. And thank you to all of you who came to this class. We will be sending out copies of the slides. The recording will be posted. And I put into the chat the link to register for the next class, which is on December 1st. And that one's all about income tax planning before and after retirement. We are currently working on the curriculum schedule for 2023, and that will be posted on Retire Ready as soon as it's ready. Once again, thank you for your time. Thank you, Ron, and have a great day.
Thank you, Lori.
Bye-bye.